Hello friends, in the series on the income tax cases, today we will discuss the case of Aircon, Beibars, FZE versus Deputy Commissioner of Income Tax. This case has been reported in 106 ITR Tribunal, short note 16, and the matter has been decided by Delhi IT80 D bench and the date of the judgment is 31st July 2023. In this case, the assessee is a non-resident corporate entity which has been incorporated under the laws of United Arab Emirates. The task of the assessee was to give on lease rental the helicopters to the various entities, and the point of litigation was that the assessee has given and raised 4 bills for the leasing of the helicopters to an Indian entity for an amount of rupees 5.28 crore, which was in dispute. Although this lease rental was in dispute, it was appearing in the 26 AS of the assessee. There was some arbitration award also given, but that arbitration order was also in dispute in the Delhi High Court. The crux of the matter was that the assessee has not received these lease rental. The assessee has not shown this income into his return of income on the pretext that this is a business income, and since the assessee do not have any permanent establishment in India, that is why it is not taxable in India. But the learned assessing officer was of the view that according to the Article 12 of the Double Taxation Avoidance Agreement read with Section 9 subsection 1 clause 6, this comes into the definition of royalty and it should be taxed under royalty. So accordingly, the assessing officer made addition of rupees 5.28 crore into the income of the assessee as royalty according to Article 12 of the Double Taxation Avoidance Agreement between India and United Arab Emirates. The assessee was before the IT80 for this addition. While delivering the judgment, the IT80 was of the opinion that according to paragraph 1, 2 and 3, if those paragraphs are read in conjunction of Article 12 of the Double Taxation Avoidance Agreement between India and United Arab Emirates, they give a clear indication that royalty in the case of Double Taxation Avoidance Agreement between India and United Arab Emirates is taxable only when it is received by the assessee and it is not taxable on the accrual basis. And there was no challenge to the fact that in this case the assessee has not received the royalty because the matter was in dispute before the Honorable Delhi High Court. So it was the viewpoint of the IT80 that in this case for the assessment year 15-16, which the learned assessing officer was saying that this amount is taxable as royalty for the assessment year 15-16 is not justified only on the point that this amount has not been received by the assessee as per the paragraph 1, 2, 3 of the Article 12 of the Double Taxation Avoidance Agreement between India and United Arab Emirates. At the same time, the IT80 also clarified this thing that the IT80 is not commenting on the issue whether the lease rental of the helicopters is taxable under the business head or the royalty head, because that is not important at this point because the amount is not taxable on the other ground, which is very clear from the Double Taxation Avoidance Agreement. Friends, this case is very important as far as of the reading of the Double Taxation Avoidance Agreement, because we have to see that whether any income is taxable as when it is received or on the accrual basis. So even the Double Taxation Avoidance Agreement has the impact of the taxability on the basis of receipt or accrual basis. At the end of this video, once again, I am repeating the name of the case. The name of the case is Aircon, Beibars, FZE versus Deputy Commissioner of Income Tax. And this case has been reported in 106 ITR Tribunal, short notes 16. The matter has been decided by Honorable IT80 Delhi ITAT D bench, and the date of the judgment is 31st July 2023.